Welcome to FDA Imports, cross-border compliance with attorney Benjamin L. England.
Welcome to FDA Imports, cross-border compliance with attorney Benjamin L. England. Benjamin is an accomplished attorney with extensive experience in FDA regulatory law and international trade compliance. As the founder of FDAImports.com, he provides strategic legal guidance to businesses navigating complex regulatory and trade challenges. My name is Kevin Rosenquist, and today we're going to talk about how to reverse an FDA import refusal or CBP seizure. Ben, good to see you. Welcome back.
Hey, thanks. Good to see you too. Happy to be here to talk about what to do when the government starts coming down on your goods.
All right, so let's start here. So what is a CBP seizure and how is it different from an FDA import refusal?
Sure. So FDA does not have seizure authority of its own. Like FDA can't seize cargo, can't really seize anything. So FDA's authority is to refuse admission to products that appear to be in violation of the law. So it's a very low standard. All the FDA needs is the appearance of a violation, and they'll detain it first, and you have a dialogue with the agency, but eventually they may refuse it. And so a refusal is nothing more than, it's nothing more. It's the FDA saying it cannot come in to the United States, it cannot be imported, and it has to be exported or destroyed. But the government doesn't take title to the goods. They don't take possession of the goods at any time in an FDA refusal. A seizure is different. A seizure, often in customs, customs does have the authority to seize cargo. They can do it administratively. And an administrative seizure requires nothing more than probable cause of a violation. In fact, one of the ways that customs often will seize FDA-regulated goods is that customs has the authority to seize cargo, and that is take possession of it, of cargo that was imported contrary to law. And in the FDA-regulated space, the law that goods are often imported contrary to when you're dealing with a customs seizure is food and drug law. So FDA might just refuse cargo and say it can't come in and it has to be exported or destroyed. But customs, when they seize cargo, they're taking possession of it. Sometimes they take physical possession of it and they remove it from your facility or from the location. Many times, customs will do what is called a constructive seizure, in which case they do not take physical possession of it, but they rope it off, they tape it off, and they basically say, you're not allowed to move it, not allowed to touch it. The goods are seized. And so this is an administrative process. You don't lose title to the goods immediately. In other words, you don't cease to own them. The government doesn't own them yet, but the government has a couple of options, and you have a couple of options in negotiating with the government, to possibly get them back, or to abandon the goods, or the government may have to go further into the case and seek forfeiture. And when they seek forfeiture of the goods, that's when they're seeking ownership and possession. So they're both serious events. The refusal event doesn't cause you to lose possession of the goods or ownership of the goods. They're still yours, and you can take them in your possession and keep them in your possession, but you have to get them out in 90 days or destroy them. Okay. Whereas with customs, you lose possession and you could lose title.
Okay. What triggers each of these generally?
For FDA, a refusal is ordinarily triggered by failing to overcome FDA's charges during a detention process. And that can happen because FDA has a product on import alert and they've automatically detained the shipment, and you've failed to, you have tested and have failed the testing. So let's say FDA has a product on import alert for filth or for salmonella or something. And you have the opportunity as the importer to overcome that evidence with testing. If you fail, then FDA will refuse the cargo. And there's notifications, there's documentation that's going on between you and the government. It shouldn't be a surprise. There's actually a deadline on your detention notice by when you need to try to correct the situation or get things to the government, at least to argue why they should not refuse it. So it shouldn't be a surprise when you hit the deadline, because it's written on the notice. You have to make sure you read the notice, and it tells you when your deadline is. With a custom seizure, that usually will happen in conjunction with some investigation. Now, it could be that they're doing some investigation where they're looking for narcotics or guns or contraband, counterfeits in some container or some shipment, and they may find a problem with your cargo. I'm not going to assume your cargo has, Kevin, that your cargo has counterfeits or narcotics in it. But it might be that your cargo.
I refuse to answer.
Yeah, that's right. Wise. You're following your attorney's advice. So there'll be an investigation usually. A lot of times there's a detention, a customs detention that happens beforehand, but not always. Customs usually has some background data that they already are aware of with respect to the importation of the goods or the people that are involved in the transaction, the import transaction, causing them to seize the cargo. That can be less like with FDA, you should arguably see a refusal coming. With customs, you may not at all. Right? It just may find that your goods got seized, and you'll get notice, and then you have an opportunity to discuss that case with customs.
So when you get these notices, whether it's the Notice of FDA Action or the CBP Seizure Notice, what should you do first? What is the first immediate step that you need to get in process?
So with an FDA refusal, you should already have been doing things. You should already have been talking to the government, trying to convince them that they should not refuse the cargo. If you've gotten to a refusal, then you have failed in that process. And so you're going to be, or either you're going to comply with that refusal, and which means that you're going to export the cargo, or you're going to destroy the cargo under government supervision. If you export it, then customs will supervise that. There's a specific form that's submitted with customs to authorize you to export the cargo. If you want to destroy it, then FDA will usually supervise that, and they'll physically go to the dump and watch you destroy it.
Wow.
I had a client just recently that destroyed a bunch of infant formula. And they met them there at the dump to watch them destroy 3 tons of infant formula.
3 tons of what?
Infant formula, 3 tons of infant formula.
Oh, infant formula. Oh, okay.
Being destroyed, at the dump. So FDA will physically supervise that. If it's a customs case, you're going to ask for all the documentation that you can get from customs, and then you're going to want the seizure notice, the grounds for the seizure, the basis of the seizure, which is going to be in the seizure notice. And then you're going to determine whether you think you have an argument, and you might hire an attorney in both of these, in this case, to argue that that customs has wrongfully seized the goods. Customs only needs probable cause for a seizure, which is it's a pretty low standard. It's the same standard that that courts will hold to law enforcement for a search warrant. It's probable cause is the same standard that they're used for seizure with customs authority. So you may seek to remit the goods. You file a petition asking customs to give them back, and what your arguments may be. You also have the option to abandon the cargo. You actually just sign away your interest in the goods, and customs will take care of it for you. Now, a lot of times they'll charge you for the cost of that, so you have to be careful when you're doing that. And then the third option is to as you're fighting it, challenge their seizure and not relent, basically, and force them to into court to forfeit the goods, in which case they can take possession and title of the goods for you for good. And that's done in a court, in a district court, federal district court. So I would say in both these cases, you want to hire somebody who knows what they're doing to look at the case to see if there's some ways that you can address it. With FDA refusals, there is a process. It's I don't even think it's in FDA's actual procedures, but there's a process for seeking rescission of an FDA refusal. I do this actually with some frequency and with pretty good success, but it's because I know which cases to take and sort of which ones to not take. I don't want to waste resources, either the client's resources or my time, trying to get a refusal rescinded from the FDA if there's just no grounds to do so. And the grounds usually are that the government, the FDA, has made a mistake. You may remember that I've said before, the government is wrong more than always, right? Because it's even when it's right, it's for exactly the wrong reason. And so the government is not always right, and that's true with refusals too. And it's perfectly fine. Like, no one's saying that people are bad; they just got it wrong. And so when you seek a rescission of a refusal, you're going to be looking for evidence that the government is wrong on the law, like they're just wrong on the application of the law, or they're wrong on the facts, or both, or or they're wrong on some policy or procedure. The way that they handled it didn't allow the importer the opportunities that they should have had in order to address the problem. And so they short-circuited the process, and they refused it improperly too early, something like that.
Okay.
And so those are the grounds for those you file a petition to the agency, it's to the agent, the officer who did the refusal, and then you sort of exercise your appeals up the chain at the FDA until you either exhaust them or you convince somebody that this is appropriate to rescind the refusal.
Can you negotiate, or is it pretty much always go to litigation if you want to try to get your goods released or not destroyed, I guess?
Sure. Well, so it'll be rare for an FDA case to go to litigation. I've taken the FDA to litigation a couple of times in the import space. And in those cases, you're usually waiting for a refusal to bring them into court, because whenever you sue the government, you have to have what's called a final agency action. The court doesn't want you suing the government on a case that's not finished, right? There's other things that you could do in order to avoid coming to court. And so they won't let you come to court if the activity, if the government's conduct is not a final agency action. Detention of imported goods is not a final agency action, because you might get them released, right? There's still a process. Refusal is a final agency action. And for many years, import alerts were considered final agency actions, but there was actually a recent case that came out of DC where they said it wasn't. The federal court said it was not a final agency action, which was a surprise. It's the first time I've ever seen a court take that position. But so rarely will an FDA case involving a rescission go to court. That's mostly because, the goods have to be worth some money, most likely, and the importer needs to be pretty desperate for the goods. Like, there has to be sort of extenuating circumstances. Customs, because they're going to take possession and they're going to try to get title, either by you giving it up through an abandonment or them going to forfeiture, they're very comfortable going to court. They get sued all the time. Customs get sued repeatedly. They almost like it. Like
they don't even flinch. They're just like, all right, put it on the pile.
Yeah, exactly. Whereas FDA, they're just like, they can't believe you're going to sue the FDA, and so and FDA also tends to be much more litigation averse. They're very risk averse. So that's actually beneficial for somebody who knows how the system works, because there's times when the case basically is a dead ringer. They're wrong, and I can point it out and show it to them. And if it's not making progress, there's times that I would bring in chief counsel's office and bring them into the issue, and I only do that when I think that I've got a case that if this goes to court, you're losing, and so and they don't want to lose in court, because there's certain things they don't want a judge to ever decide when it comes to what FDA is doing at the borders, and so they're very sensitive to that. But most of the times you're not involved in litigation with the FDA. With customs, if you keep fighting customs, they're going to go to court and seek forfeiture, or you're going to go to court to try to force them to return the goods.
Mm-hmm. What are some of the most common mistakes you see companies make with when they get these notices? Do they if they don't respond quick enough, or if they don't know how to handle it, they don't get counsel? What do you see as the biggest mistakes?
The biggest mistake sometimes happens before the refusal, and that is that they lose possession of the goods. They distribute the goods before the goods get released, and then they're now they're refused. And any portion of the goods, say 50% of the cargo gets distributed, and the other 50% is still in the warehouse where it belongs. When the goods are refused by the Food and Drug Administration, the next thing that happens is Customs issues a demand for redelivery of those goods. So Customs is those goods are only in your possession because you have a bond that's guaranteeing to Customs that if something goes wrong, you'll bring them back. Mm-hmm. And there's certain time windows when all that activity is live when that can happen. And so if you lose possession of the cargo and then FDA refuses the goods, the next step is Customs demands redelivery of the goods under the bond. And so so at that stage, you've got a problem, right? Because now you can't export or destroy all the goods. So a lot of times the problem happens before the refusal. Other times, I have clients that have never had a refusal before. They didn't know what a refusal was, and they didn't read it, and they distributed the goods. and after the refusal. That's sort of an odd circumstance. It doesn't happen very often, but it can happen. And so I would say failing to read the paper, like not reading the document, is probably the biggest mistake that people make. They just don't read it. And they also don't ask for help to understand words that they don't understand, to ask for interpretation of the words on the paper, because they're loaded, right? These are what I would call, these words are impregnated with regulatory enforcement meaning. And so if you don't pay attention, it's going to give birth to a real problem.
Yeah,
and,
right.
And you want to avoid that. With customs cases, I would say that you're almost always going to, unless you've had customs cases, seizures before, you're going to want to get some help. Because those cases are litigated with frequency. So there's case law around that issue. There's around customs seizures, and what customs can do and cannot do, and what the procedure is supposed to be, and so you're going to want to get help either from a good customs broker who really knows what they're doing, or from an attorney like me, or people that do what I do. For a rescission of a refusal, it's okay to try it and fail. And FDA is not going to be offended. For customs, you can challenge a seizure. Customs is not going to be offended. It happens all the time. If you fail at any of them, I will tell you, if you fail at a customs seizures case, it's a little harder for us to come back. What you do is you petition for the goods to be remitted to you. If you fail, you can supplement the petition. So if you fail the first time, you definitely got to get some help, because you don't want to fail twice, because you're going to lose the case. With FDA cases, you have an appeal structure, so you can appeal from the refusing officer to the supervisor, and to the supervisor, and so along the way you could pick somebody up to get some help. I often get into cases after it's been denied the first time by FDA, and people will give it a shot, and that's perfectly fine.
Okay, and finally, what is there anything that businesses can do, systems, procedures, to reduce the risk of these refusals or seizures?
Yeah, certainly it's going to be about compliance of the goods, and also knowing who it is that you are doing transaction with. Sometimes in seizure cases, it's not necessarily the goods, but it's the parties. Right? The government cares about the parties, but usually it's the goods. So compliance of the goods, ensuring that the goods comply, ensuring that they have all the proper markings for customs purposes, ensuring they have proper country of origin, ensuring that the origin that's declared, you have a certificate for that, because you're probably going to be relying on some free trade agreement in order to get reduced duty, right? Making sure you have all these documents. And then also ensuring with food and drug that you've got compliance with all the rules. Now with customs, it's not just food and drug, it's also Consumer Product Safety Commission, EPA, DEA, right? Any of those violations can also produce a customs seizure contrary to law. It's just the law of the other agency. And so customs is just the stick, right? They're the bully that's basically enforcing the other agency's laws. So compliance is critical. Knowing what you're bringing in, knowing that it's proper, knowing that it's labeled correctly, it's not adulterated. There's no misbranding, there's no misrepresentations, those kinds of things you're going to want to do. That's how you avoid these cases.
Great advice as always, Ben. All right. Well, thanks for joining us on FDA Imports Cross-Border Compliance with Benjamin England. To connect with Ben, visit FDAImports.com. And don't forget to subscribe to our channel. Leave us a review, share the episode. We got lots more great stuff coming your way. Ben, always great chatting with you. Thanks so much for the time.
Good to see you. Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.